Hey folks, Don DeRosa here. Wanted to take another second to tackle another interesting question on the internet. I started a series where I'm going to pick random questions throughout the internet on different pages, different sources, and I'm going to answer them and give you my opinion as to what that answer would be. So today's question comes from a Jan Humphreys from Sub2 Nation. And if you ever get a chance to go check it out, Jeff Rich does that Facebook page, so does a great job at it. So if you want to go check out some information, go there. But here's the question, or here's her statement. She says, I'm working on my first subject to. The potential buyer read somewhere that if the original owner were to go bankrupt, the home would be considered part of the bankruptcy. She said, I find that hard to believe. Is that true if I have the deed? Well, it's an easy question to answer, but a difficult question to answer at the same time. And here's what I'm going to say with that. It all depends on how you close this. Because there's a lot of people out there that will tell you to close. And I used to do this years ago. They do them, we call tabletop closings. I call them Waffle House closings, tabletop closings, whatever it is, where you as the investor do the paperwork, you get it notarized, and you go file it. You don't have a formal closing, but the deed transfers hands, everything is perfectly legal, and everything's filed. Well, the problem comes in what I've done. I've been doing this for 20 some years, and the problem comes in is when it gets in front of a judge, albeit in this case, a bankruptcy judge. Does the bankruptcy judge feel it is what we call an arm's length transaction? So if the bankruptcy judge feels that it looks shady, like somebody did some paperwork behind the scenes to not include the house in their bankruptcy so that they can continue to live it. Maybe they deeded it to their brother or deeded it wherever. And the bankruptcy judge finds it suspect. They will absolutely include that into the bankruptcy. Or if you're the one that bought it, you're the investor that bought it, if you're not on top of it and go there and present your case to the bankruptcy judge or the trustee, and you explain to them, hey, this is an arm's length transaction, or this is a transaction they sold the house, and it shouldn't be included in the bankruptcy, then it very well could be included in it, and then you have a real problem on your hands to prove otherwise. So there's some things that you can put in place to eliminate that or minimize that headache, if you will. And one of those things is to do what we call an arm's length transaction. Get yourself a title company, an attorney, whoever normally closes your deals, and do it through one of those. Pay title insurance, plus the homeowner that you're buying, the seller should sign what's called a disclosure or an acknowledgement that says, we call them a CYA letter, if you will. But it acknowledges that, hey, it's a written statement that they understand that the loan's going to stay in their name. They understand that they are giving up title, that they are no longer the owners, that you are the owners. They understand it's going to remain on their credit report. They understand a lot of all those things. And that's a signed and notarized disclosure. So if you do a third-party transaction, your representative, in this case would be either a title company or an attorney, would go represent you in front of the bankruptcy judge or the trustee and say, Your Honor, or Mr. Trustee or Ms. Trustee, you need to acknowledge, we need to remove this from the bankruptcy, the asset, right? Because it was truly an arm's length transaction. Now, typically what would happen if they agree to that, they would give special dispensation, and that asset would be released, and the homeowner would also be released from the bankruptcy as debt on their credit report. But it has to be agreed upon by the trustee and the bankruptcy judge. More importantly, the bankruptcy judge, because it's the trustee's job to present all this to the bankruptcy judge, whoever that may be. So the short answer is it very well could hurt your sale or could hinder title if you don't have the right paperwork. The long answer to that is you just got to get the paperwork in place. You got to make sure you do an arm's length transaction, and you have, really, it's the necessary paperwork so that you can show when that happens that it's no longer owned by them. And you need to stay on top of it. So you need to tell your seller that is considering filing bankruptcy, if that's ever the case, please contact you immediately, because it makes it more challenging and a little more difficult after the fact, after the judge has ruled and included that all in the bankruptcy. That makes it a little bit more challenging for you to get it removed. Not impossible, but it does make it more challenging than if you were there originally at the creditor's hearings, so you could present your case and say it needs to be excluded. So yes, it could present a problem, but you can avoid it if you follow a few steps, and one of those steps are the correct paperwork. So I hope that answered your question. If you like that and you'd like to hear more, please give me a thumbs up. Please hit the subscribe button and the notification bell so that I can bring you more of these videos as soon as I do them. So until next time, this is Don DeRosa saying thank you very much. Happy investing.